insight into that story. We are turning our attention now towards some news that's coming from the courtrooms. The Supreme Court has continued hearing a writ petition filed by Justice Yashwant Varma challenging the legality of the Parliamentary Committee under the Judges Inquiry Act 1968 for inquiry over the discovery of unaccounted cash currencies at his official residence. The bench comprises Justices Deepankar Datta and Satish Chandra Sharma, and yesterday the court was informed that the motion for impeachment was rejected by Deputy Chairman of the Rajya Sabha. Joining us on the broadcast is my colleague Sambhav Sharma with more on this. Sambhav, take us through the details of the hearing that and the writ petition that is being filed regarding Justice Yashwant Varma.
Today was the day 2 hearing of this particular case where Justice Yashwant Varma has filed a petition challenging legality of the Parliamentary Committee formed under the Judges Inquiry Act over alleged recovery of unaccounted cash. The matter was before Justice Deepankar Datta and Satish Chandra Sharma, and today major arguments were made by Senior Advocate Siddharth Luthra, and he argued that identical motions with the same allegations were moved in both houses of Parliament and questioned whether they could meet different outcomes. Siddharth Luthra was arguing before the two-judge bench of the Supreme Court in this particular case for Justice Yashwant Varma, and Siddharth Luthra said that Deputy Chairman rejected the motion without proper consideration, and he also argued that Article 124 Clause 4 and 124 Clause 5 of Indian Constitution exclusively govern the procedures for removal of judges, excluding the application of Article 91. On the other hand, Senior Advocate Mukul Rohgi submitted that Article 124 of Indian Constitution, Clause 5 of it, is a special constitutional provision and forms a complete code for judge removal proceedings. And also Solicitor General Tushar Mehta has argued that unless demonstrable prejudice is shown, constitution of the committee cannot be challenged. And also he added that joint committee formation becomes relevant only if motions are admitted in both houses of the Parliament. So these were the arguments made in the Supreme Court before the two-judge bench of the Supreme Court, and hearing is concluded for today, and Supreme Court was hearing this Justice Yashwant Varma's petition challenging the legality of the Parliamentary Committee.
Sambhav, I'll request you to stay on with us. We have some more inputs on this story. Appearing for Justice Varma, Senior Advocate Mukul Rohgi has now stated to the Supreme Court that Article 91 has no place in the scheme for removal of a judge. It applies only for normal business of the House. The second proposition is even if 91 is to apply, it will lead to an absurdity. Along with that, Rohgi has also stated that Article 124(5) is a special provision intended to regulate the procedure for removal of a judge. It is not part of a normal business of the House. It is the nature of a special business. It covers entire field relating to the removal of a judge, and Article 124(5) has no comparison with Article 119, 118 and 119 actually operate in the same field, that is normal business of the House. There is a distinction between normal business of the House and a special business of which that is not normally the role of the House, but given by the Constitution that says that you are a sovereign body, you will have the power over constitutional authority. That's why it's very special and it's a code by itself. Now, speaking on the writ petition filed against the parliamentary panel under the Judges Inquiry Act 1968 for inquiry over the discovery of unaccounted cash currencies at Justice Varma's official residence, his lawyer advocate Rohgi has also stated that Article 91 will not apply because there will be conflict of interest if you apply it. In case the deputy chairman is also absent, then the president will have to appoint a third person. But the deputy chairman and the third person both could be signatories to the motion. The deputy chairman acts as a member unless he is called upon in an exigency to come to the chair. He sits as a member so that a deputy chairman or a person appointed by the president may be a signatory, causing a clear case of conflict. So, Sambhav, if I can understand through these arguments that are coming to the fore, they are talking about a conflict of interest. Take us through what that means.
Well, here, arguments by Senior Advocate Siddharth Luthra and Senior Advocate Mukul Rohski are made in the Supreme Court before two-judge bench of the Supreme Court of Justice Deepankar Datta and Justice Satish Chandra Sharma. The two-judge bench of the Supreme Court is hearing Justice Yashwant Varma's petition challenging the legality of the Parliamentary Committee probing corruption allegations against Justice Yashwant Varma. Here, Senior Advocate Mukul Rohski argued that allowing Deputy Chairman to act could lead to conflict of interest. So he is talking about some kind of conflict of interest which could arise from the situation, as he argued that allowing Deputy Chairman to act could lead to conflict of interest, as such persons may also be signatories to the motion. However, on the other hand, Solicitor General Tushar Mehta argued that unless demonstrable prejudice is shown, constitution of the committee cannot be challenged. He also said that joint committee formation becomes relevant only if motions are admitted in both houses.
Ji, all right. Thank you so much, Sambhav, for all those details on that front. We are turning our attention now